Hi, my name is George Zamora with Trident Real Estate, and today I want to talk about what's the proper way to handle a move out for your rental property in Miami. For starters, the best way to handle a move out is to have been prepared before the tenant moved in. Prior to moving, it's good to document the conditions of the property either by taking photos or videos of the interior condition, and if it's a single family home, the exterior condition as well. When you take the pictures or videos, you should share them with the tenants either via email or a digital file sharing service, because this way it'll be timestamped and it will help eliminate any doubt later on as to what the condition of the property was. If you've done this process before the tenant moved in, then the physical inspection of the property after the tenant has left should be a breeze. But let's say that you haven't done this. If your lease is not specific in terms of move-out requirements, what should you look for? What's normal wear and tear? Understand that it is not the tenant's responsibility to leave the property ready turnkey so that a new tenant can move in. There are certain wear and tear items that you cannot charge the tenant for. For example, if the tenant has not painted the property, you cannot charge them for scuff marks on the walls. If they did paint the walls any color other than the original color that they received the property, you can charge them for having to prime the walls. You can't charge them for nail holes, but you can charge them for holes that are typically larger than the size of a quarter. If the property is carpeted and the carpets have wear marks from foot traffic, you can't charge them for that, but of course you could charge them if they left the carpets dirty. Essentially, you can't charge tenants for anything that could have occurred with normal use of the property during their tenancy. So what can you charge the tenant for? The obvious thing is intentional damage, which examples could include a hole in a wall or a door that was created by the tenant by either punching or kicking it, a cracked or broken light fixture, deep scratches in the wood floors, or a dented or scratched appliance. If the tenant left any furniture or any other personal item behind, you can charge them for the removal. In terms of cleaning, as a general rule of thumb, the floor should be broom swept, ceiling fans should be free of any dust and dirt, there should not be any soap scum or mold in the bathroom tiles, the stove should be free of grease, and the rest of the appliances should be clean. Well, what if there are damages? Understand that you cannot just arbitrarily claim the entire security deposit if, let's say, the tenant left a couch behind. You should charge the tenant the amount it costs you to correct the specific damage they're responsible for. In the example of the couch, you would charge the tenant the cost to hire a debris hauling company to remove the couch and then refund the rest of the deposit back to them. If the tenant broke a light fixture, you would charge them the cost of the light fixture. In regards to any deductions of the security deposit, you need to always think whether you can justify the charge in court. I can't stress enough that there's no better way to justify deduction if you have documentation, so make certain that you keep photos and receipts. Once you've itemized all the deductions, in Florida, you have a specific period of time in which to refund the security deposit. If there's no deductions, then you have 15 days from the point where they turn possession over to you. If there are any deductions, then you have 30 days from the point where they turn possession over to you. If there are deductions, then you need to write a letter to the tenant itemizing the damages, and there is a very specific language which the state of Florida requires you to include in the letter. For that specific language, you can reach out to me and I can provide it to you, or you can look it up online. Once the letter's ready, you need to send it to the tenants via certified mail return receipt. The law allows the tenant to object to charges up to 15 days after they've received the letter. If you followed the advice I've given you, then you shouldn't have any issues with the tenants contesting the charges, especially if you followed my advice to document the conditions of the property prior to move-in. If you have any questions or comments about this video, I'd love to hear from you. I'm George Zamora with Trident Real Estate.